Good morning, everyone. Happy Friday to you. Thank you so much for joining us today. My name is Cindy Flynn. I think you all know me, but my firm is Hackler Flynn and Associates, and we focus all on employment defense, protecting and defending business owners only. And today's topic is going to be remote workers. And if anyone has any other things that are on your mind that you want to talk about that you think might be good for a webinar, we're always trying to listen to our clients and put something together on what's the most beneficial, most valuable for you. So if you have any great ideas, please share them with me. You can send me an email. So today we're going to be talking about remote workers and in the face of COVID. And I just think, so many people have switched to remote workers over the last year and a half. And so we just want to make sure we're doing everything up to speed with employment law. And we're always here to protect you and defend you against anything that should arise on behalf of your employees. With that being said, I am an attorney, so I do have a disclaimer that content on this webinar should not be considered legal advice. It's really just for informational purposes only. Lots of times it's specific to your type of business or something that you're going through specifically, but communications made through this webinar and or participating in it do not create an attorney-client relationship. And then we're not responsible for any content that you can access through third parties that may be linked to this webinar. So today's topics, we're going to be talking about some best practices for returning to work, remote worker policies, COVID-19 vaccination implementation plans, employee classification overview, and then jurisdictional issues that have come up. So returning to the office, California's face covering mandate was last expanded and updated on June 15th of this year to conform to the most recent guidance from the CDC and really ease the restrictions for individuals vaccinated against COVID-19. Under the latest guidance, fully vaccinated individuals no longer need to wear face coverings indoors unless in specific circumstances, settings such as public transit or indoors at schools and healthcare settings. Unvaccinated individuals are still required to wear face coverings indoors. On June 17th, Cal OSHA issued emergency temporary standards, which was also revised to conform to the latest state guidance and allowing individuals vaccinated against COVID-19 to work without face coverings in most circumstances. We have had a number of clients in the food and beverage space or in the restaurant space continue to have their employees wear face coverings, but that is up to you. In certain circumstances, you can allow your employees who are vaccinated to work without face coverings. For all employees not fully vaccinated, employers must provide face coverings and ensure that they're worn properly, right, over the nose and mouth. We've been doing this for a year and a half now. Hopefully everybody knows how to wear your face coverings properly now when they're indoors or in vehicles. And a face covering specifically means a surgical mask or a medical procedure mask or a respiratory worn voluntary or some sort of tightly woven fabric of at least 2 layers. There can't be any holes or openings. I often see people wear their masks on their heads. That doesn't count, of course. And the coverings must include covering the nose and mouth. It also clarified that the term does not include a scarf, a ski mask, a bandana, a turtleneck, a collar, or a single layer of fabric. So that was expanded. So if you do have your employees wearing bandanas, you want to change that immediately. There are certain exceptions to the face covering requirement when employees are alone in a room or a vehicle, when they're eating or drinking, provided that they're 6 feet apart from others. I did hear that they may move that 6 feet requirement to 10 feet when you're in the break room, because you do have your mask off, you are eating and drinking, but I haven't seen that come down yet. When your employees wear employer required respirators, if they cannot wear a face covering due to a medical or mental health condition or disability, or of course, if they're performing a task that cannot feasibly be performed with a face covering. Now, face coverings are required when there is an outbreak. And an outbreak is defined as 3 or more employees with COVID-19 in the workplace within a 2-week period. In that case, in the case of an outbreak, all employees in the exposed group, regardless of vaccination status, must wear face coverings when indoors or when outdoors and less than 6 feet apart from each other, unless one of the exceptions applies. And then employers' policies must include a way of communicating the face covering requirement to non-employees. If you've been to LA and any restaurant, they now have the sign on the door that says face coverings required for all. That's one way to communicate that requirement for your non-employees who are entering your facility. And then regardless of vaccination status, employers must provide face coverings to employees upon request. In addition to these important updates, many employers are phasing employees back into the office slowly and incorporating some sort of hybrid work schedule. Some are even going to keep employees on some sort of hybrid remote work schedule permanently. However, this is a popular decision that does come with challenges, just like most things with your employees. Some of the challenges I wanted to talk about with remote work arrangements can generate a number of legal issues relating to both federal and state laws. And because California's wage and hour laws apply equally to employees working remotely, this means that having an employee who works remotely does not excuse your obligations under the law, and your liability is the same as if your employee worked in your brick and mortar building. And so what comes up with a worker being off-site, it becomes very difficult to determine what expenses are reimbursable business expenses, tracking time worked, tracking any overtime liability, any compliance with meal and rest periods, and then working off the clock can become an issue as well. Employers, though, are still responsible to ensure compliance with federal and state wage and hour laws, regardless of where the employee is physically working. So if you establish a remote work or telecommuting policy that can help you systematically approach these issues that can arise due to the lack of supervision or perceived favoritism or claims of unfair treatment among your various employees. And these things aren't difficult to add, but you want to make sure you're still tracking time, that you have a policy specifically that says do not work off the clock, that you're having your non-exempt employees clock in and out for meal periods and rest periods and keeping track of that. So if you have any questions on that, please reach out. Let's see here. So, and I see some questions in the chat. I will get to that in just a minute. So objective analysis. Initially, the first step in assessing whether a specific person is appropriately suited for remote work or a hybrid schedule, you need to make that objective analysis. And that's why just a well-crafted policy can assist with making that determination. Some positions, of course, are not suited for remote work. I mean, we represent quite a few manufacturing companies and all different types of manufacturing, whether it's food or electricity or beer. It's hard to be making beer at home without the proper food permits and everything else that goes along with that. So of course, just some positions are not suited for remote work. But if you have certain positions within your company that are more office or clerical or a lot of customer service, those types of employees can effectively perform their duties from home, and they're able to work remotely. Obviously, COVID-19 and the pandemic was a unique situation. However, it has provided many employers with some direction as to which positions in their company could potentially be suited for remote long-term work. A remote work policy, of course, allows you to objectively respond to any requests that you get from your employees and eliminates that subjectivity. Some additional issues you want to consider when you are developing a remote work policy can include the need to keep accurate records for hours worked for the employee, logistics for supporting remote employees' needs, such as support staff, office supplies and equipment. Employees who require lots of staff, supplies, or equipment should not necessarily be excluded from consideration, but factor this into your decision making, right? The cost of setting up a remote employee who only requires a laptop and printer is much different than one who requires lots of specialized equipment. But either way, just remember to evaluate the positions objectively and then be consistent as well. For example, office attendance requirements, such as which meetings require physical attendance by remote employees and which can be managed by phone or online or on Zoom, could be covered within your policy, or at least how to determine which meetings require in-person attendance and which don't. Business hours need to be set just as they would be in a regular brick and mortar office. You really need to stay away from very vague, well, just work when you need to standards. That just doesn't work, especially for your non-exempt employees, where you can inadvertently expose your business to liability for failure to pay for all hours worked, or failure to pay overtime, or failure to pay for penalties owed for missed meal and rest periods. In addition, you want to think about home office expenses and expectations for traveling and parking at the company and how those will be handled as well. Remember, if you have your employees working remotely, they likely need internet, and so you want to reimburse them for internet, or at least a portion of their internet. It could be a set amount, and same with their cell phone. Keep those things in mind. When it comes to creating your remote work policy, there's no one-size-fits-all approach. You may have different policies for different groups of workers or different departments, just depending on their circumstances. For example, your non-exempt employees who are required to clock in and clock out may have a different policy from your exempt employees who aren't subject to those same strict requirements. However, regardless of whether your employees are permanently remote or working in a hybrid schedule, business expense reimbursement is one of the biggest landmines for employers. And so I want to just touch on business expense reimbursement. This is section 2802, as it states on the slide, of the California Labor Code, and that requires you to reimburse your employees for the reasonable and necessary expenses that they incur in direct consequence of discharging their job duties, so in the course of their employment. And this case says that the purpose of that statute is to prevent employers from passing their operating expenses on to their employees. Now, I have had clients have, I have actually two people in my office, two sets of people, I should say, that are married. And I've had clients say, well, I have 3 roommates who work together at the office, and they're going to get a windfall if I pay each of them $50 a month for internet reimbursement, and their internet bill is only $110. Well, whatever you decide, you need to keep it consistently among your employees. So yes, they may get a $40 collective windfall by paying them a little too much for their internet, but whatever you do, you need to make sure that it is, you can just offer to pay for everybody's full internet bill, or decide to pay for it. Maybe if their internet bill is $100 a month and they have one person working for the company in that household, but 3 people live there who are all adults using it, maybe you pay a third of theirs. So either way, it just needs to be reasonable business expense reimbursement. And that section of the Labor Code liberally applies to many expenses that employers may be required to incur to perform their jobs, including their vehicle expenses, travel expenses, cell phone, and of course, internet plans like we talked about. A lot of companies sort of had a BYOD, bring your own device, with their remote work programs, and the potential obligation to reimburse employees for remote expenses is just not limited to California. Many other states are doing this as well. So if you are one of the companies that we represent or that we know, and you have employees working in other states, make sure you speak with local counsel about those business reimbursement expenses. Because Illinois, I know, adopted it, Montana adopted it, New Hampshire adopted it, South Dakota, and other states. So, and by the way, we only practice in California and New York, but if you do need legal help in other states, I probably know a great lawyer to introduce you to. I have a huge network of attorneys that I know who do all types of law. So if you need somebody in California who does another type of law, or if you need somebody who is in another state that does employment law, I'm always happy to make introductions. And then I just wanted to touch on very quickly the Novak versus Boeing case, where remote work expenses historically have not been reimbursable under California law because of telecommuting and remote work opportunities were optional. They were not mandated by the employer. As many companies have, that option work from home programs that are at the employee's convenience, and that's what Boeing had in this case, adverse to Novak. So Boeing offered its employees the option of voluntarily participating in a virtual worker program, and one participant, it only takes one, sued Boeing under California's reimbursement law, alleging that his home office expenses were not reimbursed. And Boeing filed a motion for summary judgment. The Central District of California ended up holding that the expenses associated with working out of a home office were not necessary expenses as a matter of law, where participation in work at home was optional. The employer made physical workspaces and computers and phones all available in the office, and even approved virtual workers sometimes splitting their homes. However, I do want to note that if an office does not make physical workspace available to its employees, the result would have been very different, just like in the Aguilar case. And Aguilar was a cleaning supplies company. They expected their sales employees to work from home to call customers, place internet sales, and the court here found an employer was required to reimburse its employees for personal cell phone and internet expenses because it was a foreseeable and clearly anticipated cost of doing business. So the next question I always get here is, how do you determine how much is a reasonable reimbursement? And that's really the Cochran case, although it doesn't give an exact percentage, of like 10% or 90%, but it at least provides some guidance on how to calculate a reasonable reimbursement for the mandatory use of personal cell phone devices. And employers must compensate their employees for a reasonable percentage of the employee's cell phone bill. And I would extend this case, even though it only talked about cell phone bills, I would extend that to home internet as well. It's something people often forget about when they're having their employees work remotely. And then where the expense is necessary, reimbursement could be required regardless of whether the employee would have otherwise incurred such expenses. So this basically means that an employer could be required to reasonably compensate employees for, say, a portion of their cell phone bill, even if they were already planning to pay for those services for their personal use anyways. Okay, now we are going to get into the vaccine. The key question, as a business owner, do you want to mandate or do you want to recommend the vaccine? And, the world has been opening back up. I hope it stays that way, but we'll see. And employees are returning to work. That question has been coming up more and more, so I thought it was pretty relevant to talk about today. You want to factor in logistical issues, community considerations, as well as legal and employee relation considerations that impact each worker or group of workers. On March 4th of this year, the California Department of Fair Employment and Housing updated its FAQs that go along with this. And just so you know, the DFEH is responsible for enforcing the California Fair Employment and Housing Act, which prohibits California employers from discriminating against employees based on certain characteristics, including disability. And FEHA mandates that employers engage in an interactive process with employees and provide reasonable accommodation to employees with disabilities so that they can perform the essential functions of their job. Now, a couple FAQs to highlight are here, where it confirms that employers can mandate that employees receive an FDA-approved vaccination without violating FEHA, so long as their employer reasonably accommodates employees' disabilities or sincerely held religious beliefs or practices. Similarly, it confirmed that employers must engage in the interactive process with employees who have one of those two things, the disability-related reason or a sincerely held religious belief not to be vaccinated. It also emphasized that an employer must determine the availability of a reasonable accommodation on a case-by-case basis. In addition to working from home as a reasonable accommodation for disability-related reasons, they suggest that employers and employees consider reasonable safeguards and procedures that employers might be able to put in place so that employees could either work at their work site without endangering themselves or other employees or third parties. And then the FAQs stated that FEHA does not require employers to reasonably accommodate employees who refuse to be vaccinated for reasons that do not relate to one of those two things, disability or religion. So, I know there's this thing going on right now about the anti-vax movement. And if somebody on your team is just an anti-vaxxer because they don't trust the vaccine yet or whatever their reason, they never get the flu shot, so why should they get this? That does not count as someone you have to reasonably accommodate because it doesn't fall under a disability or a religious belief. So you can discipline your employees who refuse to get vaccinated as long as the discipline is not retaliatory. So what does that mean? For example, you may not discipline an employee for requesting a reasonable accommodation related to his or her known disability or sincerely held religious belief, right? But the FAQs reiterate the fact that employers may not retaliate against an employee who claims that the employer's vaccination policy intentionally discriminates on the basis of race, national origin, or another protected characteristic, or has a disparate impact on a protected group. And then the DFEH recognizes that employers that administer their own vaccination programs may ask employees questions that could elicit information about a disability. So if the employer asks such questions, those questions must be job related and consistent with business necessity. So for example, if an employee objects to being vaccinated, the employer could ask whether that employee's decision is based on a need for an accommodation related to a disability or some other reason. And then this question is something I got in the chat. Related to, I guess, can an employer ask the vaccine record when hiring a new employee or mandate as requirements for hiring? So you want to stay away from, once somebody is working for your company, that is different than a candidate that might be coming to your company. And so I would stay away from asking for it before somebody starts work. But once somebody does start work, the DFEH has assured us that employers can require employees to provide proof of vaccination. Of course, you have to keep that information as confidential and treat it as a medical record. And then we've seen the EEOC provide very similar guidance. The EEOC is the Equal Employment Opportunity Commission, and it's been updating its guidance throughout the last year and a half. They've allowed for more flexibility for employers in terms of medical inquiries to permit inquiries regarding COVID-19 symptoms and medical examinations for COVID-19 testing. These are the main points. There's a lot of background and history about this since really December, but the main things to know are, that a vaccine is not a medical examination under the ADA, which is great, that it doesn't have to be job related or consistent with a business necessity because they found out that it was a direct threat. You can mandate vaccines. Of course, you need to be careful with that because of the two reasons. You want to make sure you're not discriminated against anybody with a disability or sincerely held religious belief. And then, employees can be excused based on disability or other medical reasons, religious practices, of course. And then employers can ask employees for documentation or confirmation of the vaccine. And remember, that's an employee, not a potential candidate. For voluntary vaccinations, if that's the type of policy you have, what do you mean by discipline for refusal? Where did I say that? This one. So the FAQs here state that you cannot discipline an employee who refuses to be vaccinated, or you can discipline an employee who refuses to get vaccinated, but it can't be retaliatory. And When I say retaliatory, it means that they are claiming that your vaccination policy intentionally discriminates, or it's based on a protected characteristic or something along those lines. So you can discipline them in the fact that, I mean, essentially you can fire anybody who doesn't get vaccinated, but just be very, very careful with that, because you need to make sure, and I think I have a list coming up of all the things you want to check prior to terminating someone. You know, is it possible for them to work remotely and just stay away and out of the office with everyone? Do they have a sincerely held religious belief? So that's what I mean there. You know, your discipline cannot be retaliatory. So I hope that makes sense. Getting back to just some things about the voluntary basis of it. There are two components of the voluntary nature of the vaccine. Choosing whether or not to be vaccinated is one part of it, and then choosing whether or not to respond to pre-screening questionnaires. In dealing with either voluntary choice, the important takeaway for you as an employer is not to discriminate or retaliate against employees, who decline to participate. So you need to avoid claims of hostile work environment. You know, we've seen a lot of people, or a lot of companies, you know, want to put badges on people who are vaccinated or not vaccinated, and that could create a claim for hostile work environment. You know, you're calling out those who may have a disability or a sincerely held religious belief who are protected. And so you want to stay away from things like that. You don't want employees to be harassed by other employees for failing to participate in something like this. For mandatory vaccinations, they are permissible, of course. Everyone under the sun has said that you can mandate your vaccines. But of course, you know, you don't want to necessarily just go ahead and fire everybody who doesn't get vaccinated. And I keep saying this, but the two reasons are the sincerely held religious belief or disability. So the ADA allows an employer to have a qualification standard that includes that an individual shall not pose a direct threat to the health or safety of individuals in the workplace. However, if a safety-based qualification, like a vaccine requirement, screens out or tends to screen out individuals with disabilities, the employer must show an unvaccinated employee would pose a direct threat due to the significant risk of substantial harm to the health and safety of those basically around them. So according to the EEOC, this requires an individualized assessment as to whether a direct threat exists, which is why it's really important to take every employee who comes to you and says, I can't get vaccinated, or I don't want to get vaccinated, or whatever the reason is, to do that individualized assessment. And this is basically the 4-step inquiry on what you need to do. The burden is always on us, the employer, in an individualized assessment, right? So with that, you need to determine whether you need to look at the duration of the risk, the nature and severity of the potential harm, the likelihood that harm is going to occur, and the imminence. For example, if you had employees who have been working on site for the last year and a half, it's going to be very difficult to now say that they pose a direct threat and that they have to get mandated. So keep that in mind, unless, you know, there's some extenuating circumstances. So question in the chat, can a vaccinated employee choose to work from home instead in fear of the possibility of non-vaccinated employees around the office? So what you want to do is well, I guess it depends, right? Are they in a job position to where they can work remotely? And assuming that answer is yes, I mean, I would say it's up to the employer, right? If you have somebody who's vaccinated, you can essentially force them to come in, just like you can force your employees to get COVID-19 tested to show that they have a negative. You can force your employees to wear face masks. You can do those types of things. Essentially, though, to answer your question, not any extenuating circumstance, the answer is no. unless you want to choose to allow that. Okay, if an employer determines an employee does possess some direct threat, right, like they have COVID, or they're whatever they're doing, you cannot exclude them from the workplace or take any other action unless there's no way to provide a reasonable accommodation absent undue hardship that would either eliminate or reduce this risk so that the unvaccinated employee does not pose a direct threat. And this is the slide that I was referring to earlier. At this point, if there is no reasonable accommodation that exists, which would eliminate or reduce the risk, you need to determine if there are any other leaves, rights, policies that would apply to assist this employee. For example, do you have a remote work policy, FFCRA leave, FMLA or CFRA leave? I don't know if I have this in this presentation, but if you are a little bit of a smaller company, CFRA now comes into effect if you have 5 or more employees. I can send you information on that if you need it. Just email me at the bottom. Or if the employer offers any other leave options that might be available. So now this is part of the analysis, right? So if an employee cannot be vaccinated for COVID-19 because of a disability and there is no reasonable accommodation possible, then it is lawful for the employer to exclude that employee from the workplace. However, it doesn't mean that you should automatically terminate. The EEOC specifically cautions against this, and the employer needs to consult with legal counsel to determine if any other rights under any other laws, either federally or state or local, could come into effect prior to terminating. And this is going to be a minefield for employers. And so just stop and ask your lawyer, whether it's me or anybody else, before you actually terminate someone. To touch on religious accommodations, similarly, if an employee indicates they're unable to receive a vaccination because of a sincerely held religious belief or practice, you have to take some care before just automatically excluding them from the workplace. It's a bit different than disability, but you need to take these requests just as seriously. The EEOC has explained that the definition of religion is very broad. It protects religious beliefs, practices, observances with which the employer may be unfamiliar with. So even if you are not familiar with the type of religion that your employee is claiming that they're a part of, you should ordinarily assume that the employee's request is based upon a sincerely held belief. If you do have an objective basis for questioning either the religious nature or the sincerity of that belief, you are justified in requesting additional supporting information. But let me just tell you this, as a practical matter, there is a very low burden to establish undue hardship when you're dealing with a religious accommodation. You should use the same approach to reasonable accommodation through the interactive process. And this is because the EEOC actually uses identical language in grouping ADA and religious issues, in stating that if no reasonable accommodation is possible, it is lawful to exclude that employee from the workplace. But they qualify it exactly as they do with ADA issues, in stating that it doesn't mean that you can automatically terminate the worker, and you have to determine if any other rights apply. So we recommend approaching religious requests for accommodations the same as ADA issues. And then just to touch on privacy issues, which comes up as well, even though the EEOC doesn't consider a vaccine a medical examination, you want to be careful about California's Confidentiality of Medical Information Act, which requires employers to protect the privacy and security of any medical information they receive. And this would include information collected and disclosed in relation to a vaccination or employer vaccination program. So just some key takeaways that we think employers should choose if you want to recommend it to your employees. Consult the CDC's toolkit to assist in educating the workforce about getting the COVID-19 vaccine. Consider the impact of offering employees rewards or incentives to obtain vaccines, the method, type, and delivery of such rewards. You want to review any reward or incentive program offered to employees to obtain vaccines to ensure that those incentives are not coercive. If you want your employees to get the vaccine and they're refusing to, paying them $10,000 is probably a little coercive. Giving them $100 to Amazon is fine. So just be careful. You can reward those people, but you also need to take into account the people who are not able to participate because of a protected characteristic, like a disability and a sincerely held religious belief. I know, it's weird. It's weird. If you choose to mandate the vaccine in your company, your policy should include, training your managers, your supervisors, your HR professionals on how to recognize an accommodation request from an employee who has that disability or sincerely held religious belief, and how to respond to the request, including by possibly engaging in that interactive process we talked about. You want them to be prepared to make reasonable accommodations for those employees who can't be vaccinated due to a protected reason, or those who may have a health concern, even if they are fully vaccinated, such as like immunocompromised individuals, and consider the feasibility of the accommodation examples offered by the EEOC. You want to monitor the current spread of COVID and employee vaccination rates to determine whether unvaccinated employees should in fact be excluded from the workforce. Offer the same or similar job adjustments to pregnant employees who are unable to get vaccinated. You want to consider mask wearing, social distancing, and other requirements in the workplace, which we've talked about, and then take steps to protect and maintain the confidentiality of any medical information that you receive for your employees. Now, we are more confident than ever that mandatory vaccination policies are going to be upheld if employee pursues litigation. There was a case in Texas I wanted to just quickly mention that came out in June, on June 12th, that rejected an attempt by a Houston medical worker or I guess a group of workers, to challenge the legality of their employer's decision to require that all employees receive the COVID-19 vaccine. So in this lawsuit, there were 117 hospital workers who sued to block the hospital's mandatory vaccination policy, as well as the termination of anybody who was unwilling to comply with the employer's mandate that all employees get the vaccine. The employees asserted that the vaccine mandate would result in wrongful termination in violation of public policy of the state, Texas state and federal law. And the district court rejected the employee's wrongful termination claim and determined that although Texas doesn't recognize a wrongful termination claim in violation of public policy, even if it did, as California does, the hospital's injection requirement is consistent with public policy, and it cited a very old US Supreme Court decision that ruled that compulsory vaccination was not a violation of due process. So the court went on, further explained that the EEOC updated its guidance to allow for this. So I think that that's really important to note, that Texas case. I mean, it happened in Texas. Although California is a little bit different, I can still see it being upheld here in California because all of the guidance has said that you can do that. You can mandate the vaccine. So, pivoting to remote work in 2020 was challenging for a lot of businesses. We're going to be talking about employee classification and exempt and non-exempt. Your exempt employees fall under generally one of these few categories. The top three are really the most used. But you may be opening up yourself to liability with your non-exempt employees. And that is basically anyone who doesn't fall under a specific exemption. All non-exempt employees are covered by state and federal wage and hour laws. To avoid paying overtime premiums, an employee must be exempt from overtime requirements of both state and federal. With employee classification, and I have a whole presentation on just employee classification alone. If you're interested, let me know. But basically, there's a few things. So you have to fall under one of those exemptions and then also meet the minimum salary test. Under California law, the most common exemptions requires employees to earn a minimum monthly salary of no less than 2 times the state minimum wage for full-time employment, and that salary must be a predetermined sum. The minimum amount may not be prorated for part-time work. And I think a lot of companies could have gotten in trouble over the last year if they took a full-time exempt employee who was making, let's say, 80K, dropped them down to half-time, now they're only paying 40K, but that puts them out of the exempt status. So be very cautious of that if you are doing that. There's, just to make it even complicated for everybody in California, if you are an employer with 25 or less employees, the state minimum wage is $13 an hour, and that was as of January 1st of 2021. That monthly, or I'll just go with the annual minimum, is $54,080 per year. Now, for employers with 26 or more employees, the state minimum wage was $14 as of January 1st of 2021. And so that equates to $58,240 annually. And how I see clients getting into trouble is that they have somebody on salary who is, let's say, $50,000 as of December 30th, 31st, and then January 1st, they are immediately out of compliance because they have not increased that minimum monthly or minimum annual salary. So keep that in mind. And now they have to receive a predetermined amount each pay period. It can't be based on the number of hours worked. It has to be the same amount every time. Aside from any exceptions, the exempt employee must receive his or her full salary for any week in which an employee performs any work without regard to the number of days or hours worked. As a general rule, you need not pay an exempt employee for any work week in which they perform no work. And then primarily engages in exempt work. Now, to determine if the employee primarily engages in exempt work, you want to examine all the work the employee performs during the work week. The labor commissioner considers the amount of time the employee spends on exempt work, as well as your realistic expectations and the realistic requirements on the job. So in general, the employee must spend 50% of his, her, they time performing exempt duties. You really want to exercise caution here if you have managers that supervise employees at the same time that perform routine non-exempt tasks, such as stocking shelves or managing the phone line. We have had clients sued where, they call everybody manager, but they're not actually performing exempt work 50% or more of the time, or at least that's what they claim. Another big area of employee classification for your exempt employees, they must use discretion and independent judgment. That the employee has the power to make independent choices pertaining to matters of significance that is free from the immediate supervision, or that they have the ability to make a recommendation for action that is subject to a superior's final authority. The employee must possess sufficient authority for the recommendations to affect matters of consequence to the business or its customers. And so just a couple of examples of activities that do not involve exercising discretion and independent judgment is if you have an employee applying knowledge to follow a prescribed procedure. So if you have an SOP, determining which procedure to follow, determining if specific standards are met, or determining if an object falls into one or another grade or class. Those are examples of activities that do not involve exercising discretion and independent judgment. Obviously, almost every employee has to make some sort of decision requiring discretion, but the discretion and independent judgment exemption requires that those decisions must involve matters of consequence to the actual heart of the business. And just some common mistakes that we see as employment lawyers, I thought it'd be helpful to address the 5 most common mistakes that we see clients making. Number 5 is not maintaining workers' compensation insurance on remote employees. It's important to keep workers' comp and workplace injuries in mind, as we're required to maintain workers' compensation insurance for all employees, whether they work on-site and remotely. I know everybody on this call very much cares about their employees and very much has workers' compensation insurance. But I can't tell you how many times I have, just last week or 2 weeks ago, I had somebody in my office saying that, they have 8 hotels and they don't have workers' comp. That is important, and failing to have it is a criminal offense punishable by imprisonment of up to 1 year and a fine of, $10,000 at least. So keep that in mind. Number 4, I wanted to say is reclassifying all remote or hybrid employees as exempt. The location of an employee does not determine their classification. There is a process that you have to go through in order to determine and make that decision. Their job duties, their salary determines if that employee can be classified as exempt. Number 3, not ensuring employees have the tools needed to work remotely. If your employees need a computer, who's going to be purchasing it? Who's responsible for paying for internet? Who's responsible for paying for cell phone? As we learned today, you want to pay a reasonable percentage of both, right? And these are questions you want to work through with your employees. Number 2, not implementing a remote work policy. It really should be written down, make it clear which positions are eligible to work from home and which just are not. It also gives employees a clear guidance on how they can make that request to work from home, and how the company will then inform the employees that they are required to work from home, or required to come in. And all requests and instructions really need to be in writing here. And number 1 is failing to properly track employees' time. So under, and I see another question in the chat, are exempt employees required to clock their time? No, they're not. You don't have to do that, just your non-exempt employees. And under federal and state law, non-exempt employees must accurately and fully record and report all hours worked, including clocking in and clocking out for a meal period. So prior to allowing your non-exempt employees to work remotely, you want to have that written policy in place to ensure that non-exempt employees are properly recording and reporting their time. And this can be done in a web-based app. It can be done on a timekeeping system, manual timesheets. I mean, it really doesn't have to be anything fancy. You can just have them open up an Excel document, send it to you once a week. This is the time I started. This is the time I took my first break. This is the time I clocked back in. This is the time I took my lunch break. This is the time I clocked back in. Keep track of 2 breaks and 1 lunch for a typical 8-hour shift. In addition, you may want to remind employees that while they'll be paid for all hours worked in accordance with applicable federal and state laws, employees are not authorized to work overtime hours without the express written permission of their manager or their supervisor or any other individual within the company that has that authority to grant permission. Even if they do work overtime and it's not allowed, you still have to pay them for that overtime, yes, but you need to write them up. You can do an oral warning, a written warning, whatever it takes to write them up and say that, look, this is not allowed. This is where it is in our handbook. Don't work off the clock. Just use some sort of disciplinary procedure there. Now, no matter who I see a question in chat, can company discipline exempt employees for not clocking their time? If that's a requirement for you and you want your exempt employees to clock their time, then yes, you can certainly discipline them. But the non-exempt employees is the one where you're going to get into trouble. Now, I'm happy to answer any of the questions. I wanted to keep this short and as informational as possible for you. No matter who your employment attorney is, whether it's me or any other firm, make sure you're doing a couple check-ins with them per year. I think that that's key. We went over when California raises its minimum wage, but LA likes to be different and raise minimum wage in July. So I always recommend 2 check-ins at least per year. And then the governor tends to sign in a bunch of laws into place in September. So sometimes those are retroactive, sometimes they take effect immediately, and sometimes they go into effect January 1st. So also make sure whoever your employment attorney is, make sure they have an experienced team of attorneys behind them All the attorneys at this firm have at least 10 years, if not 20 years of employment experience specifically. And make sure you're not being passed off to somebody who doesn't specialize and practice in this niche, or make sure you're not being passed off to somebody who's right out of school. Let's face it, we all know nothing right out of school. And then lastly, if you do think you have somebody on your team who is a liability and might create a problem for you or the company later on, do a liability assessment. That can take place a number of ways. One is if you do just an internal audit of your paperwork, do you have class action waivers in place? Do you have employee agreements in place? Do you have an employee handbook that was updated recently within the last year? I really recommend that to be updated annually. The worst offender I saw, and I know they're not on this call, but they're a client of ours. It's a nonprofit. They had last updated prior to hiring us. They had last updated their employee handbook in 1972, so a little old there. But there are two ways to do a liability assessment. One is, like I just said, you can audit what you have in the company, make sure your documents are signed by everybody in the company, that sort of assessment. Or if you think one particular individual is, trying to start tape recording things, like if they come into your office with a tape recorder strapped to them, which has happened to our clients before, or if they start taking pictures of things around the office, anything that's a little sketchy, you want to know if there's any liability specifically to them, and we can do a liability assessment. That way you know what's at stake, and that way you know if you get hit with a lawsuit, what's best to proceed and what's best for your business. We are not afraid to take a case all the way through trial, but if you're going to get hit with $1 million lawsuit against you, we want to minimize that as much as possible. And that way, having that early liability assessment, you know what's at stake, right? We don't want you spending money on attorney's fees if you can just pay something and get out of it early on. But we do want to defend you all the way if there is true grounds for defense. So oftentimes, it unfortunately becomes a business decision in California. I think I am friends with everybody here on today's presentation. I'd love to keep in touch, email, telephone, office. We're in Pasadena, and we have tennis courts in the back. So if anyone wants to come play tennis with us, let us know. It's an outdoor event. And then I'm happy to take another minute, answer any questions. Oh, shoot. I just saw the Q&A. I was looking at the chat only. Let me see if I can answer some of these. One question is, can employers mandate that office visitors be vaccinated? Probably not, I would say. If you have an employee is under your control, right? You're telling them what to do every day. They're working for you. They're getting a paycheck from you. With office visitors, you want to be a little bit more cautious because you could have somebody who's not able to get vaccinated because one of the few reasons we talked about today. And so, you probably want to stay away from that. And then another question I see in the chat, can an employer mandate vaccines for all employees, even if no COVID-19 handbook policies in place? Yes, you certainly can. You can definitely do that, and you can still mandate it. It doesn't have to be in your handbook. It's like nobody knew the pandemic was coming, or at least I hope nobody knew it was coming, and so it would have been hard to have an employee handbook that talks about, a policy in place to mandate vaccines for something that hasn't yet happened. So I hope that answers your question. And that being said, I don't see any other questions either in the chat or in the Q&A. I just got another one. Can you require all employees to return to work regardless of vaccination status? You want to be a little bit careful with that. I mean, essentially, yes, you can have your employees return to work. I know that is one of the things that the owner of your company in particular is very much wanting to do. But remember, you still need to make sure everybody wears masks, that everybody, is 6 feet apart with their desks inside your office, those types of things. But you can mandate it unless somebody poses a direct threat, which then you have to do that analysis. So it's a little more tricky, but if, but like another question we got earlier is whether or not a vaccinated employee could choose to work from home because of the fear of coming into an office with non-vaccinated employees. And, the answer to that question is no, but as long as the direct threat doesn't exist and you have your employees taking all proper precautions, you can have everybody return back to work in your actual office. So that being said, I think I have answered all the questions. Thank you guys so much for joining me today. I feel like I need music or something. I feel like I'm just talking a monologue for the last hour. I want to like pump up music next time or something. But thank you so much. Enjoy your Fridays. And I hope everyone has a great weekend. I'm here if you need anything else. Thank you so much. Take care.